Welcome to the Deep Dive. Today we're jumping into California Assembly Bill 1481, and this one bill number, it turns out it has a pretty surprising kind of dual history.
It really does.
We've pulled together sources from, well, all over the Berkeley Rent Board, the California Apartment Association, SPR, the California Association of Public Hospitals and Health Systems, Assembly Member Borner statements, bill histories, you name it.
Yeah, a real mix.
Our mission today is to unpack this. We want to understand how this one number, AB 1481, played out in two totally separate areas, tenant protection and healthcare access for pregnant folks.
Right.
We know you want to get the lowdown quickly but thoroughly, so stick with us, and we promise you'll get a clear picture of what seems complicated, maybe even find a few unexpected turns along the way.
Definitely, because, the first thing we found digging into AB 1481 was, hang on, this isn't just one bill.
Exactly.
The same number, AB 1481, was used for two completely different proposals in different years. It's really like a tale of two AB 1481s.
Okay, let's tackle that tale then. Tale number one, the first AB 1481, that was around 2019, right?
Correct, 2019, primarily linked with Assemblymember Bonta.
And this one was all about tenants.
Yes, tenant protection was the focus. The big push was to establish statewide just cause eviction controls.
Okay, just cause. What exactly did that mean in this bill's version?
It meant landlords couldn't just terminate a tenancy for any reason or no reason at all. They needed a specific, allowable cause. It's interesting how bill numbers get recycled like this in different sessions.
Yeah, it can be confusing. So what were these allowable causes?
Well, they broke it down into two types. First, you had at-fault reasons. These are pretty much what you'd expect.
Like not paying rent.
Exactly. Failure to pay rent, breaking the lease agreement significantly, causing a nuisance, damaging the property, refusing to sign a similar lease renewal, or, illegal activity.
Seems reasonable, but you said two types. What was the other?
The other category was no-fault reasons. This is where the tenant hadn't necessarily done anything wrong.
Oh, okay. Like what?
Things like the owner wanting to move in themselves or taking the property off the rental market entirely. Also, if there were major health and safety issues requiring the tenant to move out, or plans for demolition, or a really substantial remodel.
Got it. So even if the tenant was following all the rules, they could still be asked to leave under no fault.
Potentially, yes. But the bill had requirements for that. Landlords would have had to state the specific just cause reason clearly in the termination notice.
And what about helping the tenant out in those no-fault situations?
That was a key part. The proposal included relocation payments for no-fault evictions. SBR, in their support letter, even suggested these should be reasonable amounts, maybe tiered based on the apartment size.
Like more for a family in a 3-bedroom than a single person in a studio?
Precisely. That was the kind of detail being discussed.
Okay, this sounds like it could have been a major shift for renters statewide. But it didn't pass, did it?
No, it didn't. It faced significant opposition. The California Apartment Association, for instance, was strongly against it.
What kind of arguments do you think they were making against just cause?
Well, typically landlord groups argue these kinds of rules make it harder to manage properties, remove problem tenants quickly, or respond to market changes. They might worry about the cost of relocation assistance or potential abuse of the system. The usual concerns about property rights versus tenant protections.
Right, and those arguments won out in that session.
Apparently so. The bill died in the assembly, meaning it didn't get enough votes to move forward.
Okay, so end of story for that AB 1481.
As a standalone bill, yes.
Yeah.
But, and this is the really crucial part, especially for anyone involved in tenant issues, the core ideas didn't just vanish.
Go on.
The main concepts from that 2019 AB 1481, especially the whole just cause eviction framework, were essentially rolled into another bill that did pass later that same year.
Which was?
AB 1482, the Tenant Protection Act of 2019.
So the ghost of the first AB 1481 lives on in AB 1482. That's the big connection.
That's exactly it. It's key to understanding how we got the current statewide tenant protections.
Okay, so remind us quickly, what did AB 1482 actually put into law?
Right. AB 1482 established statewide rent caps. That's the 5% plus local inflation, or 10% max, whichever is lower. And crucially, it enacted the just cause requirement for evictions after a tenant's been there 12 months or 24 months in some cases.
Using those same at-fault and no-fault categories.
Yes, largely the same definitions, and it does require relocation assistance for those no-fault evictions. There are exemptions, of course, like for newer buildings, some single-family homes not owned by corporations, and specific notice rules apply.
And importantly for listeners, maybe in places like Berkeley or San Francisco with their own strong rules.
Correct. AB 1482 specifically doesn't override stricter local ordinances. The Berkeley Rent Board source makes that very clear. If local laws offer more protection, those still apply.
Okay, that really clarifies the first life of AB 1481 and its legacy. A failed bill, but its ideas succeeded elsewhere.
Pretty much. A fascinating legislative path.
Now, let's pivot completely. Fast forward to 2023. There's another AB 1481, this one from Assemblymember Borner. Totally different topic.
Totally different. Zero connection to tenants or rent. This 2023 version is all about healthcare, specifically expanding medical presumptive eligibility for pregnant individuals.
Okay, presumptive eligibility. What does that mean in practice?
It's basically a way to get people temporary, immediate medical coverage while their full application is being processed.
Yeah.
This bill focused on the program for pregnant people.
And what changes did this AB 1481 make?
Several important ones.
Sure.
First, it updated the language. The program used to be called Presumptive Eligibility for Pregnant Women, or PE4PW.
Right.
The bill changed it to include all pregnant people and renamed the program Presumptive Eligibility for Pregnant People, PE4PP.
To be more inclusive, recognizing that not everyone who can get pregnant identifies as a woman.
Exactly. It's a move towards more gender-neutral and inclusive language in state programs.
Okay, that's the language part. What about the actual coverage? What was the big change there?
The really critical piece is about preventing gaps in care. Before this bill, the presumptive eligibility period was limited, maybe 60 days. If your full medical application took longer than that to get approved.
You could lose coverage right in the middle of pregnancy.
Potentially, yes. A huge problem. So this AB 1481 fixed that. It ensures that if someone is on PE4PP and applies for full Medi-Cal within that 60-day window, their presumptive coverage continues uninterrupted until a final decision approved or denied is made on their full application.
That sounds incredibly important. No gaps in prenatal care.
Absolutely vital. It removes a major source of stress and risk for pregnant individuals relying on Medi-Cal. Imagine needing a checkup or having a complication and suddenly finding out your temporary coverage expired while the paperwork was still processing. This bill prevents that scenario.
Makes perfect sense. Any other key parts to this 2023 bill?
Yes, it also requires healthcare providers who enroll people in PE4PP to give them information on how to contact their county social services department to help them follow up and potentially speed up the processing of their full medical application, just trying to make the transition smoother.
And this bill had support from healthcare groups.
Oh, strong support. Our sources mentioned the California Association of Public Hospitals and Health Systems, for example. They highlighted how crucial this is for the vulnerable communities their member hospitals serve.
And unlike its 2019 namesake, this AB 1481, it passed.
It did. Signed into law by the governor in October 2023. A successful piece of legislation.
Wow. So, same number, AB 1481, two completely different stories. One, a tenant protection bill whose ideas found life in another law. The other, a successful healthcare expansion.
It really highlights how legislation evolves, doesn't it? And how a simple number doesn't tell the whole story. It also shows perhaps shifting priorities or maybe just the different paths bills can take, one hitting roadblocks, the other finding a clearer path years later.
It's fascinating. One aimed at housing security, the other at health security during pregnancy. Both fundamental needs. Now, thinking about our listener, the attorney from the Martinez Law Center down in Santa Ana.
Right, specializing in tenant law.
Exactly. Their work is focused on representing tenants, unlawful detainers, premises liability in apartments, that kind of thing. Serving Orange County, Riverside, San Diego, LA. They only represent tenants, not landlords.
So for them, that whole history of the first AB 1481 and how it led directly into AB 1482.
That's incredibly relevant. AB 1482, the Tenant Protection Act, forms the bedrock of so many statewide tenant rights they'd be fighting for. You can check out their work at martinezlawcenter.com. That's martinezlawcenter.com. This whole story is a great example of how understanding legislative history directly impacts legal practice, especially in tenant advocacy.
Absolutely. It shows the journey of how those protections came to be. So when you pull back, what we see with AB 1481 is this single identifier attached to two very different, very significant efforts.
The tenant protection push, which didn't pass directly, but basically paved the way for AB 1482.
And then years later, the successful effort to make healthcare access during pregnancy more secure and inclusive.
So the big takeaway for you, our listener, is probably this. Don't judge a bill just by its number or even its initial title.
Right. Things can change, ideas can get folded into other legislation, and numbers can get reused for totally unrelated issues. You really have to dig a bit deeper.
It makes you wonder, doesn't it? How many other laws or policy areas have these kinds of hidden histories or evolutionary paths where one effort failed but influenced another, or where the same label got applied to something new down the line?
It's a really provocative thought. What other legislative stories are out there waiting to be uncovered? It definitely encourages a closer look at the process.
We really encourage you to dig deeper if this interests you. You can look up the actual text of AB 1482, that's California Civil Code sections 1946.2 and 1947.12, to see the tenant protections yourself.
And maybe explore the specifics of medical eligibility for pregnant people, now under the changes from the second AB 1481. Lots to explore.
Absolutely. Thanks for joining us on this deep dive into the surprising tale of AB 1481.
Call now 714-442-9741. Thank you.